Numbers 1 through 6 specifically. No, you said that.
You are unmuted.
Is that for the judge?
Yes.
Court, all rise. Hear ye, hear ye, hear ye, all parties having anything to do before the Honorable First Justice Beverly Sonoma, now sitting in the Superior Court within Fulton County and Norfolk, John Nagin, your attendance shall be heard. I'll say the Commonwealth with the court and proceed.
Judge, 22 CR 117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right, so to begin, and I have all the motions in limine. I'll talk about how exactly we'll go through them in a minute. But first, so in reviewing the motions in limine, I mean, clearly the defendant has an absolute right, a constitutional right, to present a third-party culprit defense, but counsel is well aware that that is not without limit, right, from the case law. Now, the defendant has stood here, defense counsel has stood in this court repeatedly, stood here and in other venues and in their pleadings, espousing various third-party culprit theories or scenarios. But now that it's time to actually try the case in the courtroom, I don't have a motion from the defense to admit third-party culprit testimony. So, and as you're well aware, I have to make findings before any mention of any third-party culprit evidence or even an opening goes before the jurors. You know, in order to admit it, given that I have no information at all, I mean, I don't know who the third-party culprit is, even after reading 4,500 pages of discovery. I don't know what motive a third-party culprit might have. I don't know how it's relevant. I don't know if it's remote or if it's current. I don't know if it's speculative or if it's relevant. I don't know if it will prejudice or confuse the jury. And if it's hearsay, I have a whole other series of factors I have to consider. So, Mr. Unetti, are you pursuing a third-party culprit defense?
We are, Your Honor, and I'm prepared to address that. The Commonwealth has raised the issue, and I am prepared to address that today.
So you filed your motions first, and you did not raise it. So if the Commonwealth had not raised it, you did not move to introduce it, correct? I have no motion from
No, I
from
understand.
you about it.
I understand, Your Honor. If you'd like something in writing for us, we can do that. I have a full argument prepared.
All right, so who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
How am I supposed, so you're prepared to argue all this?
I'm prepared to argue it, Judge.
All right, so we will get to that when we get to the Commonwealth's motion.
That's fine.
Now, the second thing I want to address, because again, it's very important at this point, the motion regarding the DNA, regarding excluding the DNA. Mr. Lally, why should I not allow that motion?
For a couple of reasons, Your Honor. Number one, what I can provide to the court by way of update is that most of the testing with regard to that item is complete. So first and foremost, the item is hair. That was confirmed by the body testing prior to them conducting any sort of mitochondrial testing. The mitochondrial profile, the partial profile that was generated in regard to the hair sample is complete. The mitochondrial DNA profile in regard to Mr. O'Keefe's sample is complete. The preliminary analysis that I received by way of email from Bodie yesterday indicated that they were consistent with each other. I asked for some sort of preliminary report or something that I could share with counsel based on their lab's accreditation. That did not permit them to release anything by way of a report prior to it going through a full review process. My understanding is that not only that process, but the entire lab file should be produced by Tuesday. On top of that, what I would state as far as any sort of prejudice the defendant appears that they've suffered as a result of that, there is still zero reciprocal discovery that I've received in regard to anything from counsel. And then part of the delay, at least a portion of the delay in this specific testing, as the court is aware, as you've had a chance to review Bodie Technologies' observance policy as far as outside experts, there was a significant delay in hearing from counsel and for the defendant in regard to whether or not they wish to have someone present prior.
How long a delay?
I believe it was at least several weeks, if not a month. I mean, we spoke about it in person in December, and I don't believe that I...
My order was in November.
Correct. So when we received your order was in November. What took a little time on our part was to get the samples taken from the troopers in regard to the other testing, and in order to get all of those items shipped and transported from the MSPCL to Lorton, Virginia to Bodie.
When was that done?
Late November.
Go ahead.
Then there was a evidence viewing, which both counsel attended. We spoke about it there. I think that was December 1st. And then I waited a few weeks, never heard back, followed up on it, and eventually heard back with regard to them not wishing to have anybody present for that.
When was that?
I don't have a specific date offhand, but
I need you to find it.
I can.
All right, so I didn't know that the defendant decided not to have somebody there.
Right.
And that prolonged it? They weren't able to go forward, right?
Yes.
How long will it take you to find that information?
Shouldn't take too long. I would need to check my email.
All right, I'm going to take a 5-minute recess.
Thank you.
You are muted.
Yeah.
You are unmuted.
Thank you. See you in session.
What are you handing me, Mr. Lally?
No, it's an email from Mr. Yannetti on December 22nd confirming that they do not wish to have observation for testing of the hair sample of Bodie.
All right, so that was about a month after my order?
Correct.
All right. And the defendant's asking me to exclude this in part because of the late disclosure of the information.
Yes.
All right, I'll hear from the defense on this, and then I'll give you an opportunity to address it, Mr. Lally. All right.
Thank you, Your Honor. I'd first like to address the timeline that Mr. Lally has just explained to the court. First of all, we were not made aware that we were allowed to test based on Bodie's protocols and procedures until December 1st. We were given a letter saying it would cost $21,000 for our expert to sit in on that testing. We reviewed that letter. We told Mr. Lally that it was most likely we were not going to have someone independently watch the testing because of the price.
When was that?
December 1st.
When? December 1st?
On December 1st. We
Okay.
confirmed that in writing when he emailed us again on December 22nd. And I would note for the court that Bodie did not receive the hair from the Commonwealth until January 11th.
Okay.
So there was no delay on our part. As the court knows, to date we have received no reports from the Commonwealth regarding Bodie Technologies' analysis of the DNA. The Commonwealth has engaged in repeated and inexcusable delays regarding the testing of this particular item of evidence, which at this point is sanctionable. The hair has been in law enforcement custody for more than 2 years, Your Honor. On February 1st, 2022, Massachusetts State Police criminalist Maureen Hartnett purportedly recovered a hair from the bumper of Ms. Reed's vehicle. For a full year, the Commonwealth did nothing. Finally, on March 6, 2023, criminalist Maureen Hartnett got around for the first time.
Sorry, criminalist department? Is that what you said?
Criminalist Maureen Hartnett
Okay, yes.
got around to conducting a visual inspection of that hair for the very first time. On March 6, 2023, she opined that it appeared to be human. However, subsequent discovery produced by the Commonwealth revealed that she had failed her proficiency test in that precise subject matter only 1 month prior. Then, on August 25th, 2023, the Commonwealth submitted that hair to the Massachusetts State Police lab for DNA testing, and it was forensically determined that no human DNA was detected. Almost 6 months later, the Commonwealth made their third attempt to find evidence establishing that the hair was somehow probative in this case. It is now 4 days before trial, and we were told that we're going to receive this on the day trial is set to begin. Pursuant to Massachusetts Rule of Criminal Procedure 14C, subdivisions 1 and 2, the court has the discretion to exclude evidence based on the Commonwealth's failure to comply with its discovery obligations. There's no excuse for a 2-year delay. We immediately conferred with counsel when he notified us as to what the requirements were going to be if we decided to have an expert present for testing. We got back to him the day that he emailed us following up about that, and they didn't even bother sending the hair to the lab until weeks later. So I don't think it's fair to blame the defense for a 2-year delay in this regard. As the court may know from the notices of discovery, we've received an overwhelming amount of evidence. This week, last week, the week before that, we're on the eve of trial. It is not fair to throw at us yet another item of evidence that we have to retain an expert to assess. We have to review, we have to make tactical decisions. That's not a fair position to put the defense in. We've been asking for a continuance. I think the only fair thing, if the court is going to force us to go to trial, is to exclude this evidence.
Okay, thank you very much.
Thank you, Your Honor.
Mr. Lally?
Yes, Your Honor. Again, not faulting counsel for any sort of 2-year delay period, but there was a period of time, given sort of the close nature of when the Commonwealth is receiving this information, that a couple weeks, or a few weeks in this case, do matter. The other point I would make as far as, again, as far as the defendant being prejudiced, this isn't evidence that I anticipate introducing in the first day, the first week, or probably not even the first month of trial. So whatever time counsel needs in order to retain an expert, run that by an expert, run that by one of their experts they already have, I don't know that, whether or not they have any experts, because again, I don't have anything from them. So as far as ample time, I would submit that there's more than sufficient time once the report is received for counsel to make use of it in whichever way they deem appropriate. And for that reason, and I'm certainly not asking the court to continue the trial date, but for that reason, I would ask that the motion to exclude be denied, absent any prejudice to the defendant.
All right, so I'm going to take this under advisement. And I may as well tell you that the best way, I think, for us to proceed with the rest of these motions is, because they were filed so late, which I understand they were filed, just to be clear, I know they were filed by the deadlines, but so close to trial, I don't have written oppositions, really, unless you both raised independently the same issue. So what I will do this morning is, my intention is to hear from counsel, to hear at least from the other side, if the motion itself is clear enough, but to hear from counsel. Then we'll take a break, and at 2 o'clock, we'll come back, and anything I can decide, because I know you're preparing this weekend to go to trial on Tuesday, anything I can decide by this afternoon, I will. Anything that I cannot, I will let you know. And then we'll do housekeeping, which I consider, including, though it's certainly a very important part of the case, jury voir dire in that. So that will come at the end of, that will come this afternoon. So starting with the view.
Your Honor, I was just going to notify the court, to your discretion, there are a number of motions that will be unopposed. I don't know if
All
you
right,
want
so
to-
what I'm going to do with that is, the Commonwealth filed a very helpful list of what their numbers. We have, of course, the paper number, the docketed number. So when I get to that, we'll just go through those quickly.
Whatever the court wishes.
All right, I appreciate that. So you, well, I'm probably starting with one. You could have saved yourselves time in writing the motion regarding the view, because you both want a view. I will conduct a view. You need to talk because you have different locations.
Yeah, and we've, upon consideration, Your Honor, the Commonwealth has asked for a view of 34 Fairview Road. We would be satisfied with a view of...
So you don't need to go to the waterfall?
I think that we can just agree to go to that one location.
All right, so you all figure out the view. I am going to take under advisement your request of the defendant coming with us. You know that there are all sorts of things I have to consider before deciding that.
Thank you.
Okay? So that part is under advisement. Before the end of today, figure out exactly what you want to do with the view. Mr. Lally, your office will provide state police escort for that view?
Yes, Your Honor.
Okay. All right, now our court officers, Chief Rose usually gets the bus. So, all right, so for that, the defendant's motion, it's our paper 283. Defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. So I'll hear whoever's arguing that for the Commonwealth. The Aruba incident, if you will. I mean, I'm sorry, who's arguing for the defense? That's what I'll hear from.
I am, Your Honor.
Okay?
Thank you.
Did you say 282 or
283.
282? Affidavits, 282.
Oh, this is all backwards. Pauline did this for me. All right, thank you.
Thank you.
Thank you, Your Honor. The Commonwealth seeks to admit irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence against Ms. Reed by admitting inflammatory evidence of an event that purportedly transpired in Aruba on December 31st, 2021. As the court knows, this type of propensity evidence is extraordinarily prejudicial and serves no purpose other than to assassinate Ms. Reed's character in the eyes of the jury. The Commonwealth has put forth no reliable evidence to suggest that the incident that occurred in Aruba on New Year's Eve has anything whatsoever to do with O'Keefe's death, or that this remote and isolated incident was even a point of contention in their relationship at the time in question. And we aren't left guessing, Your Honor. All of the witnesses who were present at the Waterfall Bar and Grill on January 29th, 2022, along with high-quality video surveillance footage from that night, established that Ms. Reed and Mr. O'Keefe were happy, they were in good spirits, they were getting along. There is no evidence to suggest that this incident had anything to do with the facts at issue in this case. The Commonwealth points to purported angry voicemails left on the decedent's voicemail to suggest that there was some sort of hostile relationship between Ms. Reed and Mr. O'Keefe that night. However, these voicemails were left after Ms. Reed dropped O'Keefe off at Brian Albert's residence and after he failed to come back outside to meet her. There is no logical relationship between the prior bad acts evidence in this case that the Commonwealth seeks to admit and the crime charged here, and therefore this evidence must be excluded.
Okay, Commonwealth?
Yes, Your Honor. So this also relates to Commonwealth's motion to eliminate number 20.
Yes.
So in regard to that, Your Honor, this is highly relevant evidence as it pertains to motive and as it pertains to the nature of the relationship between Mr. O'Keefe and Ms. Reed, which goes to motive, it goes to absence of accident, goes to motive, absence of mistake. And this is not as the defendant seems to continuously try to pose it as some sort of temporary or isolated incident. This isn't just the argument or the yelling of swears between the defendant and Ms. Sullivan in the lobby in Aruba. This then leads to an argument which both children indicate in their statements continued inside the room in front of them for about 20 minutes after it happened. This is also not a fleeting reference in the sense that the defendant continuously brings it up on her own. Specifically in text communications with Mr. Higgins when she's talking about the nature of their relationship. And it's not just the voicemails that the defendant leaves on Mr. O'Keefe's phone after the murder occurs in front of 34 Fairview. It's also text messages exchanged between the two of them in the days leading up to that, in which they discuss the nature of their relationship. You also have statements from the children which indicate that the victim had tried to break up with the defendant multiple times in front of them, asked her to leave the home and she refused. You also have a text communication from Mr. O'Keefe to Ms. Reed in which he indicates that he thinks that their relationship is essentially run
What was
its
the
course.
date of that one?
I believe that was the 28th. Then there's other text messages from the defendant to Mr. O'Keefe referring to their relationship between themselves and with the children as toxic. These are further statements regarding infidelity which continue on to the morning of, in which statements that she makes in the backseat of the vehicle with Ms. McCabe and Ms. Roberts as they're looking for Mr. O'Keefe just prior to locating his body on the front lawn of 34 Fairview. These are statements regarding her belief of Mr. O'Keefe's infidelity that she repeats again when she's having her recorded interview with Ms. Voss from Boston Magazine. These are not isolated statements. These are not just one time 4 weeks prior. It's not too remote in time, and it does show sort of the nature of the relationship and as it's evolving over the course of that month, from the date of the incident in Aruba all the way through until the date that Mr. O'Keefe is killed. In furtherance of that, also, there are statements that the defendant makes to paramedics when she's being treated on scene that the last time that she saw Mr. O'Keefe, they got into a fight or an argument, and she's upset because that's the last time that they spoke was during the course of a fight or an argument in front of the house on Fairview Road. So it literally continues from the Aruba incident all the way through to the murder's occurrence. So for those reasons, the Commonwealth would submit that it is relevant as to motive, it is relevant as to absence of accident, and it is relevant as to absence of mistake. Thank you.
All right. What I will need is exactly what the Commonwealth intends to introduce. I think you've outlined it, and I'm familiar with it. If I admit it, it would certainly be accompanied by very strong curative instructions, which you know is my right. I've heard argument now. I'm going to think about this and maybe decide it by this afternoon, but.
Okay. Thank you.
Okay. All right, so you were both in agreement on what's the defendant's motion to exclude irrelevant and prejudicial evidence regarding alleged harassment and/or intimidation of a witness, and the Commonwealth's, for different grounds and different scope, actually, motion to exclude mention of Aiden Kearney, AKA Turtle Boy, and his pending criminal charges for witness intimidation. So, though you both agree it's out, that doesn't necessarily mean that I agree with you that it should be out. I understand that the nature of the harassment, mindful of the grand jury minutes that I've read, that in response to some of the questions posed by those at the U.S. Attorney's Office, the answers explained away some conduct as a result of the extraordinary harassment witnesses were undergoing. So I'm not sure I agree with you. So go ahead and try and persuade me, but what I'm inclined to do is keep it out in the case in chief, but Commonwealth said you told your witnesses not to discuss it. So I'll hear the defendant.
Just a moment.
I guess I would start, Your Honor, by saying that in order for evidence to come in, it has to be elicited by a party. It has to be offered by a party. You're being told that the Commonwealth does not intend to elicit this evidence and that the defense does not intend to elicit this evidence. So I guess the question that I would direct to the court is, do you intend to follow up with questions?
I'm not questioning the jury. It's clear that it may be a response, a natural response by a witness that neither one of you intended to get as a reason for something, right, that I'm not going to sanction the witness because I allowed the Commonwealth's motion.
Sure. So,
Mr. Yannetti,
yes.
So it's clearly you try your case the way you want to try your case, and the Commonwealth decides how they want to do it. But I am not tying the hands of witnesses to natural responses to questions. So I'm taking this under advisement. If you open the door, it comes in.
Well, I completely understand that, Your Honor. I will say that I think probably, I don't want to speak for Mr. Lally, but I think...
So don't speak for Mr. Lally. I'll hear from him in a minute.
I'll speak for myself then, if the court will allow me, which is that if a witness opens the door to, a further explanation of this, that could give rise to both sides exploring that, which, I suppose we'll deal with that when it comes to it.
The way the motion's written, it would be prohibited, and witnesses, I'm not tying the hands of witnesses to natural answers that are the result of questions asked by counsel.
Right, understood.
Okay? Do you understand that, Mr. Lally?
Oh, absolutely, Your Honor. And that was not my intent, is if a
How the
question...
motion reads, your motion reads, Mr. Lally.
I understand. But it was more of a notice that the Commonwealth doesn't seek to introduce any evidence of that, but at the same time, obviously, if the truthful and honest answer to a question that's posed of a witness references that, then I think it comes in.
All right. So I think we're all on the same page. Neither of you intends to introduce this in your cases, but if you open the door, or if it's a natural response from a witness, it comes in. Okay. All right, so Jim, is 289 defendant's motion eliminated to exclude the plasma, serum plasma, the blood, the alcohol testing? Or are my numbers all off?
That's 289.
Yeah. All right, and the Commonwealth has a paragraph or two responding in one of your other motions. So I will hear the defendant on the motion regarding the testing of the blood from the hospital for the alcohol levels.
Thank you, Your Honor. I'll be addressing this with the court's permission. This is number, just so we keep it clear in my head, I had named this number 17, dealing with the retrograde extrapolation.
Okay, we don't have it as 17 anywhere.
I thought that was the list that the helpful list that the Commonwealth.
Oh, okay, so
Right.
Our number is 289.
Right. Okay. So.
And the Commonwealth's one paragraph response is 17, but you filed the motion, so why don't we hear from you as the moving party?
Thank you. So the Commonwealth wishes to have Ms. Reed's retrograde extrapolation records admitted over, naturally, a hearsay objection, because the Commonwealth, their position is that they are medical records. The Commonwealth misapprehends the definition, the base definition of what a medical record is. A medical record, as the court well knows, holds a very special place in the evidence code, and that's because it's not compiled in anticipation of litigation. And for that reason and that reason only, they're deemed non-testimonial and not subject to Crawford and the defendant's right to confront and cross-examine witnesses or the experts behind the reports. Medical records are different than what we have here. The extrapolation records we have here are not medical records that were generated for treatment or Ms. Reed's medical history. They're the opposite. Those records were generated specifically in anticipation of litigation and in association with this criminal investigation. Thus, they are rank hearsay. The Commonwealth claims that the records are not produced in anticipation of litigation, stating basically that during her hospitalization, law enforcement was at the, quote, beginning stages of their investigation. But what the Commonwealth fails to mention or address is that at approximately 6:30 a.m. on a dash cam video, an Officer Good, as a matter of fact, a Canton police officer, states to Detective Lank that he is going to, quote unquote, section her, which the court knows what that phrase means. He's going to place a hold on her medically. Thus, the clear intent of law enforcement hours before the blood draw was actually taken was to keep her under law enforcement's thumb as she was an immediate suspect. But there's a bigger issue, Your Honor, and that is that the parties lack the essential, both, and by the way, this goes to the Commonwealth as well, the Commonwealth, but more importantly, the defense, we all lack the essential information on how the blood was actually drawn and tested. Those standardized protocols that we all get used to in the average OUI case, drunk driving case, they don't exist here. The standardized protocols for reliable testing, they're tried and true, and every one of those protocols is missing or are missing, and that leaves the defense having to sort of guess at the validity of the underlying test, and the validity of the underlying test is the foundation on which the extrapolation is made, which is the only thing the Commonwealth really cares about. They don't care about the underlying test, they care about extrapolating backward several hours. But this sort of goes along the theme of garbage in, garbage out. If the underlying test was not valid, or it can't be proven to be valid, then, of course, the extrapolation is also invalid. The question remaining is, was the testing done by gas chromatography? Was it enzymatic testing? We don't know, and we'll never find out. We don't have reports to suggest that, or exactly what the validity of those tests were. So the initial result is suspect, and by extension, the extrapolation is also suspect. It bears pointing out, Your Honor, and this is the only sort of granular detail I want to get into, the extrapolation, according to the Commonwealth's expert, is somewhere between 0.13 and 0.29 blood alcohol concentration. That is a swing of more than 123%. In other words, the swing of the extrapolation is larger than any one of the numbers themselves, which means it simply cannot be reliable. It illustrates the invalidity of the underlying serum plasma test, and for those reasons, the defense objects to the admission of both the blood test, the underlying test, as well as the concomitant extrapolation.
Okay, thank you. Kamala?
Your Honor, so what the Commonwealth would submit is this may have been a valid basis for a motion to suppress, but it was a motion to suppress that was never filed, and one that the defendant specifically waived. That Mr. Yannetti waived all motions to suppress. As it pertains to Mr. Roberts from the Office of Alcohol Testing's testimony regarding the serum conversion and the retrograde extrapolation, the reason for the range is because it's math, and essentially taking into account a number of different variables. That is why the range is as it is. As it pertains to the specific item that would be introduced into evidence, meaning the defendant's medical records, that's what the Commonwealth is referring to as the records coming in. Mr. Roberts would come in and testify as to his own analysis, his mathematical calculations, and the results based on his training and experience, which the defendant has had for over 2 years, as Mr. Roberts testified at the grand jury to that exact set of scenarios. As it pertains to the testing itself, the Commonwealth, as indicated on its proposed final pretrial memorandum, has summoned in not only the doctor who ordered the testing, the registered nurse, the nurse practitioner, who would both have been involved in the taking of the sample from the defendant pursuant to her medical treatment and medical diagnoses, as well as the director of the lab at Good Samaritan Medical Center, who would testify as to what kind of testing is done and the nature of that testing and everything else. As it pertains to those witnesses, if the defendant wishes to conduct some sort of voir dire prior to the testimony in front of the jury, I certainly have no objection to that. But any sort of voir dire of Mr. Roberts or exclusion of his testimony would be inappropriate based on the fact that the defendant has had more than ample notice as to what the parameters of that testimony would be. So as far as what would be coming in as an exhibit, it would be the medical records with that amount in it, and there would be testimony from essentially anyone and everyone involved in the ordering, taking, and analyzing of that particular sample, which then provides the basis for Mr. Roberts' testimony.
Okay. So I have like one small paragraph from the Commonwealth on this. I want a memo on this.
Sure.
All right, so I'll take this under advisement.
EM 17. They're 17.
Yeah, there's 17 we still need to address some of. All right. So that's all of the defendant's motions in limine, correct, Mr. Yannetti?
Let me just have a moment.
Mr. Jackson, it's all of them, isn't it?
We filed a motion for attorney-conducted panel voir dire.
Yeah, that's a joint motion, and that's, I already said we're going to talk about impanelment this afternoon.
Just being complete in answer to the court's question. That was one that was not addressed, but that's fine.
All right. Oh, the request just to have panel, your motion was a little bit confusing.
Right.
So you want panel voir dire?
Panel voir dire, correct.
I'm not going to do panel voir dire in this case. So we'll talk about the particulars of it later this afternoon. All right, so on the Commonwealth's list of motions, you said that there are some that you may agree with. What besides the view? Are there any of these numbers?
Yes, Your Honor. The defense does not object to the Commonwealth's motions in limine numbers 1 through 6. Number 8.
1 through 6.
Yes, number 8. Number 9. Number 11, we obviously joined in that request.
Yes.
Let's see. Number 14, we do not object to. Number 15, we have no objection in principle, but we do reserve the right to object to just individual exhibits as they come.
Yep.
Number 18, we have no objection. Number 19, we have no objection. Number 23, no objection. Number 26, no objection. I believe the court
That's
did
the one we
address
addressed, yeah.
And number 32, we have no objection.
All right, thank you. All right, Mr. Lally, I will hear you on our paper 297, your number 7.
So, Your Honor, this is the Commonwealth's motion to preclude reference and redact the manner of death contained on the victim's death certificate. This is a routine motion the Commonwealth files in really respect to any case. Manner of death.
That's not persuasive, so go ahead.
No. And I'm just, manner of death, as elucidated in the motion, is not something that is typically something that is permissible to be testified to from anybody to the jury, because that's sort of the question of liability ultimately that is left to their discretion as far as how they find the facts. But cause of death, obviously, is something that is a medical determination. Manner of death, as the court is well aware, is there are essentially 3 or 4 different selections, and they fall into different categories. They don't necessarily mean in the medical context what they might mean in the legal context. So for that just sort of simple differentiation of meaning between the two, manner of death is not something that the Commonwealth feels is appropriate for the court, for any witness to be testifying to as far as the jury is concerned, as that's a question for them ultimately to determine. And for those reasons, the Commonwealth would ask that this motion be allowed.
All right, who's responding to this?
Thank you, Your Honor. The medical examiner who completed the death certificate in this case concluded that the manner of death was undetermined. The Commonwealth now seeks to have that portion of the death certificate redacted because it is quite clearly exculpatory. All of the cases cited by the Commonwealth deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death as a homicide, because it violates a defendant's right to due process and a fair trial under the 5th, 16th, and 14th Amendments to the United States Constitutions. None of the cases cited by the Commonwealth stand for the proposition that a medical examiner's determination that the manner of death is undetermined should be redacted. In fact, the Commonwealth cites Commonwealth versus Ellis at 373 Mass 1, it's a 1977 case, for the proposition that excluding the word undetermined is the better and safer course. But that's a misstatement of the law, and I would urge the court to read the Supreme Judicial Court's opinion in that case. What it actually says is this, quote, "Nothing contained in the record of a death which has reference to the question of liability for causing death shall be admissible in evidence. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that list of words that the Supreme Judicial Court warned about is the word undetermined." That is what the Commonwealth seeks to have redacted here. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred, and their own medical examiner has opined that she was unable to make that determination. That finding is relevant, it's exculpatory, and there's no authority that supports its redaction. Thank you.
All right, Mr. Lally, the medical examiner will be on your witness list, right? I haven't seen either of yours witness list.
Yeah, sure.
Okay, so I'll take this under advisement. All right, Mr. Lally, you're number 10, our number 300.
Yes, Your Honor. In this motion, the Commonwealth is simply seeking to obtain CORI information or records of potential jurors. Not looking for information pertaining to jurors that as they come in or some voluminous amount of every possible potential juror, but only seated jurors. And essentially, what the Commonwealth is requesting is to simply have some sort of verification that the answers that are provided by the jurors are true and accurate. This is something that is permitted by the case law, it's permitted by the statute, and it's obviously something that the Commonwealth would share with the defense as required to, but the timing of it, of what I'm asking for, and the limited scope that I'm asking for in relation to just seated jurors once we have a full sort of set of jurors, whether that be 12, 16, whatever the court chooses as far as the number, I'm assuming approximately 16 or so. But once those are seated, the Commonwealth's just asking for some time to run those CORIs and provide those to counsel and then make any further objections for cause prior to the jury being sworn.
Okay. So I know you're not in agreement. Are you opposing this?
Yes, Your Honor. Your Honor, we object for several reasons. First, the jurors are given a questionnaire which specifically asks this question. They self-report. We rely on self-reporting from jurors with regard to all questions. The Commonwealth has cherry-picked this one question to verify whether or not they're telling the truth without dealing with any of the other questions that the jurors are asked. This proceeding right now, like many of these proceedings, is being broadcast widely, publicly. There are potential jurors out now listening to this, I'm sure, waiting for an answer from the court as to whether or not they will undergo that further invasion of privacy. And they are also, I would submit, aware that in this unusual case, the Commonwealth, through their special prosecutor, has sought to charge picketers, protesters in a very unusual manner, we would claim a harassing manner, and our position is that this is just another method of harassment. We believe it's unfair. We ask the court to deny this motion.
Do you have any case law to support your argument, Mr. Yannetti?
Your Honor, the case law is simply the constitutional rights to privacy that the jurors have. I mean, it's an issue of fairness, Judge. So that's what we're relying on.
All right. So the motion is allowed, Mr. Clerk, number 300.
Thank you.
All right. Mr. Lally, you're coming into number 12 with me quite skeptical. Number 12, leading questions for 13 and 16-year-olds.
And again, Your Honor, let me just first start by saying I don't think that this is something that's going to be absolutely necessary, given what I know of the two child witnesses in this case. Only filing under abundance of caution, more so should the need arise based on less so the age of the child, but the age of the child taken in conjunction or in the context of sort of the atmosphere of testifying specifically in this case, in this courtroom, with different things going on as far as the amount of people and things of that nature. So again, I don't foresee this being an issue, but just an issue that I wanted to flag for the court. Should it become an issue, and seek sort of the court's ruling or permission in regard to it prior to any sort of incident arising.
Okay, given that caveat, is there any objection?
No objection at this point, Your Honor. We can address it as it arises.
Okay. Mr. Lally, keep in mind the jurors would much rather hear from the witnesses than from the Commonwealth.
Of course.
All right. Mr. Clerk, on that, we're just going to withhold ruling. Withhold ruling until a later time. Commonwealth, you'll raise this again if need be.
Yes, sir.
All right. All right. So on your next motion, your number 13, I had it, I don't have it in order. Just give me a minute. So I'm curious, do you happen to have, oh, we don't have the screen up. Do you happen, I'd like to see exactly what it is that you intend to introduce. So this is your motion eliminate to admit evidence that the defendant was in custody for a period of time after her arrest. Jim, is it possible for you to print that for me?
13.
Yes, please. Thank you, okay. All right, I'll hear you on this, Mr. Lally, and remind me the date that this body cam footage was taken.
So, Your Honor, this is in reference to the defendant's arrest post-indictment by the grand jury in this case. So it's June 9th, 2022.
So that's why I have not seen the video itself.
Correct, and that's certainly something that the Commonwealth can provide for the court. But essentially, when she's arrested and during the booking process at the Milton State Police Barracks, the troopers who conducted that arrest were wearing a body-worn camera pursuant to their BWC policy with the state police. Counsel has a copy of the policy, counsel has a copy of the video, and essentially there are a number of different statements which provide sort of third, fourth, fifth, sixth, I'm not sure what number we're up to at this point, of sort of varying accounts that the defendant has provided to numerous people.
Can you give me an idea now? Do you know the substance?
So the substance of these particular statements is the defendant, Ms. Reed, continuously is told by Sergeant Buchanan to essentially stop talking. He's advised her of her Miranda and advised her to stop making statements, and repeatedly states that to her during the course of her making statements. But the sum and substance of it is she says something to the effect of, you know, are you in on the joke? And then makes some sort of reference to having witnessed Brian Albert and Colin Albert essentially smashed John O'Keefe's head into the taillight, indicating that that's how her taillight was broken. Doesn't make any sort of further statements about why she would then leave the scene after that occurred or anything like that. But these are, again, different accounts that have been made in direct variance to prior statements that she made January 29th to the troopers, to paramedics, to treating medical professionals, to Ms. Roberts, to Ms. McCabe, to the niece of Mr. O'Keefe, to a whole other sort of slew and variety of people with a different sort of variation on what transpired each time. So it's sort of inextricably intertwined with the fact that she's in custody.
How so? Is she in handcuffs? Is she in a cell?
She's seated at the booking desk or the booking rail in the State Police Barracks. So, I mean, I don't need to make direct reference to it. It's just, again, it's something out of an abundance of caution based on sort of where it is and when it is that the statements are made, that it may naturally sort of come out as far as if the court wishes. I think it's something that the court can cure by issuing a curative instruction if there's any prejudice to be suffered by the defendant. But again, it is a statement by the defendant, which is admissible, as the court is well aware. And then it is sort of in the confines or in the context of her being in custody when she makes that statement. I certainly wouldn't be trying to elicit testimony that she was in custody, but it is kind of apparent that she is.
Can you have that here for this afternoon?
Yes, I can arrange for that.
So we can see it?
Sure.
All right, what's the defendant's position here?
We object. Your Honor, we're in a situation now where the Commonwealth arrested Ms. Reed twice when they didn't have to. I made the argument to you at arraignment back in June of 2022 that after John O'Keefe was found dead on the lawn of Brian Albert's home, I immediately got a letter out to the state police saying, I represent her, I will surrender her, no need to arrest her, just call me and I'll bring her in. They ignored that, and they arrested her to get her into custody. I would assert, ultimately, to make the arguments that Mr. Lally's making today. Then, astonishingly to me, after the grand jury issued indictments, based on basically no new evidence, they upcharged her and once again did not contact me, despite the fact that she was completely in compliance with the terms of her release and had made every court appearance. They arrested her again. And so, again, I would assert to be in the position that they are in today. With regard to the case that they cited, Your Honor, Hoffer does not stand for the proposition that they claim that it does. In fact, the issue of that defendant being taken into custody was stricken by the court. The testimony in that case that was allowed or sanctioned by the SJC was evidence that the defendant had been living with his girlfriend but had unexplained absences. He didn't get along with her son. She was afraid of him, and that he associated with a convict that made her nervous. There was nothing about him being in custody that was admitted in that case. To the extent that these statements are, or the court deems these statements to be relevant and admissible, there are other ways to do it. I do urge the court to watch the video.
Yeah, I think we'll put it on the screen because I want to see how the jury would look at it.
Okay, that's fine. But I will suggest, Your Honor, that there are other ways to accomplish that, you know, either to have testimony about what it was, or failing that, to have the audio of my client making whatever statements they seek to introduce without the video. An image of my client, you know, in handcuffs at a police station is what this court generally tries to avoid, given the fact that as she sits here and as this trial is ongoing, she's presumed to be innocent. We wouldn't bring her up here in an orange jumpsuit and then ask the jury to make decisions about her, nor should we display her you know, after a perp walk at the police station in handcuffs, making these statements.
All right, so I need the Commonwealth to, do you have your media person available, Ms. Gilman or Ms. Crawford or whomever?
Yes.
All right.
We're seeking to make arrangements for that.
All right, we'll put it on the screen just so I can see how the jury would see it. All right, thank you. So that's, we'll look at that this afternoon. All right, so I'll hear you on the celebrate motion, your motion number 16, Mr. Lally.
Thank you, Your Honor. So in this motion, what the Commonwealth is requesting is for permission for the Celebrite expert, Mr. Whiffen, to conduct a demonstration in the courtroom during the course of his testimony in regard to the examination that he did in regard to Ms. McCabe's extraction report, and specifically the alleged search, which the defendant purports occurred at 2:27 in the morning, and the Commonwealth maintains occurred at 6:23 and 6:24.
I'm going to stop you because one question is, how long will this take if we allow it? How long will the demonstration take?
So really what I'm seeking to do ideally would be for sort of a live demonstration, which I had Mr. Whiffen do and record, and provided a copy of that to counsel as well. So that recording that I provided has no audio to it, but there was also a PowerPoint presentation that Mr. Whiffen prepared in relation to the same issue that he produced, and then I provided that to counsel as well, which essentially goes through what he did. And it also—
You're not looking to do a PowerPoint presentation, are you?
No. The PowerPoint presentation would not be something I'd be looking to admit. The reason I did the video is in the event that technology is not our friend on that particular day and the live demonstration doesn't work, I would then be seeking to introduce the video and have him talk about it while it's playing. It mirrors essentially are exactly what Mr. Whiffen had included in his report, which was done back in almost a year ago at this point and has been provided to council, and is essentially the same thing as what's contained in his report, but just as far as a visual aid and demonstration for the jury. I just think it's a bit when particularly talking about sort of the technical aspects of his particular analysis, the Commonwealth would submit that it would be helpful and assistive to the jury in order for them to have that sort of visual demonstration to go along with obviously the oral testimony of the witness as well.
All right, who's arguing this for the defendant?
Thank you, Your Honor. We received from the Commonwealth the video that Mr. Lally just described about 48 hours ago. So we have not had an opportunity to confer with our expert about that particular issue.
Okay.
However, just from sort of a cursory review, it does appear that its admission is improper. As the Commonwealth acknowledges in its motion, in order for the court to allow a courtroom experiment or reenactment, there are very strict rules concerning that experiment. It has to replicate with exactitude the actual event so that it is fair and informative for the jury. Otherwise, it's prejudicial and would serve only to confuse the jurors. Here, just based on a cursory review, it does not appear that Mr. Whiffen's in-court experiment replicates all of the factors that we know were in existence at the time in question.
Does it replicate the factors that he says he considered?
So I'll need to have a little additional time if the court doesn't mind to confer with my expert.
Yeah, so I will give you time to confer with your expert and file a written response. But that's one of the factors that I'm asking you to look into.
Understood. And then just, if the court does intend, after a written briefing, to consider admitting that evidence, we would ask to be able to take their expert on voir dire as to that particular issue.
Okay.
Thank you.
All right. How much time, Ms. Little, do you think you'd need to confer with your expert and put something in writing?
I believe about a week should be sufficient, Your Honor.
Okay.
Thank you.
And I'm sorry, I neglected to answer the court's question as far as timing. The video demonstration, which is essentially what I'd be asking him to do, is about 19, 20 minutes.
Okay. All right. So, Mr. Clerk, that's under advisement. So what remains on Commonwealth's motion 17? The statement, so so I know this also went to the blood draw, but there were statements. That's what separates this from the defense motion to exclude the testing. So I'll hear you on that.
Sure.
Is the defense objecting to that portion of the Commonwealth's motion?
Thank you for that opportunity. Not particularly, no. It's the blood draw and the extrapolation.
Yeah, so the motion had both, so that's why, all right, so I guess we don't need to hear, so the part of your motion that concerns the statements made by the defendant, the defense is not objecting to?
No, very obviously, they're admissions, and everybody knows what the rules are dealing with admissions, so I'm not concerned about that.
Okay. All right, so Jim, on 307, it's a split. The Commonwealth is permitted to introduce statements made for purposes of medical treatment. And the certified medical records. But there's an objection as to what we've heard regarding the alcohol testing, the blood testing for alcohol. Okay. All right. You're number 20, Mr. Lally. Our number
20, Your Honor, I believe, refers back to the same argument that the Commonwealth had made in opposition to the defendant's motion to exclude anything about the nature of the relationship.
Okay.
Things of that.
That's why I don't have it right here. Okay. 21, the out-of-court statements regarding the victim's state of mind.
So 21 sort of pertains to that same issue as 20. So essentially, it's the same argument, Your Honor, same facts underlying it as far as statements that the victim, Mr. O'Keefe, made to...
But were you making statements regarding like bins in those cases, Commonwealth versus bins, the state of mind of the defendant, state of mind of the victim, the defendant knowing it, the defendant being able to act as a result specifically? Okay.
So on that sort of specific application of it, and that's why we filed two separate motions in relation to it. But as it applies to that, the Commonwealth would submit it as clearly met its burden under the case law as it applies to that because of the nature of some of those communications. So it's not just communications that are observed by other parties as far as what the victim, Mr. O'Keefe, indicated to Ms. Reed, or these aren't situations like in some of the case law where it's an indication to a third party and the defendant wasn't present, and then there's sort of an inference that can be made that, well, if they're saying it to this friend of theirs, then they must have communicated that to the person with whom they were in the relationship with. In this instance, Your Honor, we have direct communication between Mr. O'Keefe and Ms. Reed via text communications from each of their phones indicating that that communication about ending the relationship was made just prior to the date of his death in this particular case. So it not only enhances, but what I would submit is corroborates that testimony from other sources or from other family members and other witnesses. So for those reasons, the Commonwealth would ask that its motion be allowed.
All right.
Your Honor, on this motion, our position is that we'd like more specificity about which statements the Commonwealth is indicating they seek to admit. I imagine
It's the same thing I said to you, Mr. Lally, on the other one that was
right
in connection with this. So the Commonwealth will do that?
Yes, Your Honor.
Okay.
And I think then at that point we can evaluate it, Your Honor. Certainly some of these statements are going to come in, but we'd like the opportunity to be able to object if they are not admissible.
I agree, so it has to be clearer. So, as far as your notice to the defense, you can even point to grand jury minutes or whatever, but I need to know the statements you intend to introduce.
Understood, Your Honor. And what I can do and what I aim to do just sort of in an ancillary thing is I'd like to, if the court is amenable and counsel is amenable, to pre-mark as many exhibits as possible just to make the situation easier for both sides as far as referencing documents, photographs, videos, things of that nature. So when it comes to, I'm not seeking to introduce, when it comes to any sort of the cell phone extractions, I'm certainly not opposed to admitting the entire extraction dump essentially from anybody's individual phone. But what I'd like to do as far as exhibits are concerned is to print out or create sort of extraction reports from those cell phones as far as different communications between person A, person B, just to make it more simple for the jury to digest it and more simple for, I think, everyone involved to understand sort of the exact communications that we intend to talk about. So in that vein as well, what I can do is provide a supplemental memorandum in regard to 20 and 21, referencing sort of those specific conversations.
Okay, that'd be great. And if you can work together, and this will be part of the housekeeping we talk about this afternoon, work together to pre-mark exhibits, that would be great. All right, so 22.
So again, with respect to 22, and I think the same can probably be said for 23 and 24 and 25, is that essentially, as I've stated earlier, the Commonwealth is somewhat operating in the dark, and that I don't have any discovery, I don't have a witness list, I don't have any investigator reports or notes or notice of an expert or notice of any sort of expert reports, curriculum vitae, really anything. So out of an abundance of caution, the Commonwealth filed motion to eliminate numbered as 22, which is in reference to any alleged bad character or any prior misconduct of the victim or any witness that the defendant alleges to seek to elicit through whatever witnesses they may or may not have. But essentially, what I would state in regard to this specific issue is that, as the court is well aware, it has to be something that is, first of all, relevant to anything, and it also has to be relevant to a reputation and not just an anecdotal something that's brought up from one witness, again, who I don't even know who those witnesses would be at this time. So I don't know that the court can rule on it without any sort of notice as to whether or not the defendant intends to seek to introduce such evidence or has any such evidence or who those witnesses would be or what their level of knowledge would be, but it's something that I at least wanted to flag for the court in regard to if it comes up as we go along.
Who's responding?
That would be me, Your Honor. Thank you.
Okay.
This will be very brief. The Commonwealth, at least in their moving papers, Mr. Lally, I think, has gently stepped back from the moving papers a little bit. The moving papers suggest that they seek to preclude the defense from presenting any evidence to the jury that one or more of their witnesses lied or gave false information in this case in any particular. They call this, they do this under the rubric of bad character, but that misunderstands or misapprehends what character evidence actually is. Character evidence or bad character evidence refers to using past behaviors or past traits of a person to prove a propensity to act in a certain way in the future. Conversely, proving that someone lied or gave false or misleading information in regards to a specific matter that's relevant and material to the case at hand, that's called impeachment. And that's allowed in every single courtroom across
So
the country.
impeachment's certainly allowed, but do you intend to put on witnesses regarding challenging character evidence?
No, we're not intending to. That's exactly what I was going to summarize by saying the bad character focuses on general character traits, whereas impeachment deals with people who lied or were untruthful. We intend to do the latter.
Hold on, Mr. Lally, you're not objecting to impeachment, prior inconsistent statements, things like that?
No, of course
so
not.
So Counsel, you mentioned that there is a distinction between character evidence and straight impeachment. Character evidence is not permissible because you're not going to introduce it, you said, right?
We're not seeking to introduce it at this point, and we wouldn't. I mean, obviously, the trial has to play out, and it's going to be several weeks. And by the way, Mr. Lally has mentioned over and over and over about how he has no reports and no statements, et cetera. He's got more than 7,000 reports and statements, both from his own investigation and from the federal investigation, that in no small part encapsulates a lot of what we intend to impeach with. However, as I stand here today, I can report to the court that we don't intend at this juncture to put on bad character evidence. We don't know what that might look like, but if we did, obviously I know the rules. I would give the Commonwealth due notice and the court notice before we went that direction.
All right, so 312, Mr. Clerk, is allowed. If you need to readdress that, defense counsel, you need to file a motion. Okay, so 312, Jim, is allowed. Same thing, do you intend to put on character evidence? It's a difficult standard or potentially problematic, but do you intend to do it?
Your Honor, we at this juncture do not intend to put on character evidence, but we will give the court notice as well as Mr. Lally notice if we do change our mind.
All right, so 313, Jim, is allowed and defendants can renew it.
I'm sorry, what's the second part?
Defendants can renew it
Yeah.
by written motion. How about 24? Is there an objection to that?
I believe that was 24.
No, that was.
No, it's 23.
Oh,
did
I apologize. 23, we had said we had no objection.
Okay, I didn't have
And
that.
24 is the opinion or character.
Okay, so 24 is, all right.
I'm sorry.
24 is allowed, Jim? 23 and 24 are allowed. All right, there's an objection to 25, Ms. Little? Just
Yes,
yes
Your
or no?
Honor. Mr.
All right,
Jackson is-
so I'm going to hear from Mr. Lally on the motion. I just wanted to know if there was an objection.
Your Honor, I could
probably, if I don't mean to step on Mr. Lala's toes. If he wants to talk, he can talk. We don't anticipate asking any of our experts to read from a treatise. If that's what his concern is, and that's how I read the motion, we don't anticipate going there. That might short circuit this.
So no treatise, no studies?
They will refer to studies, not going to read from studies on the witness stand at this point, at this juncture. Certainly, their studies are the foundation of every expert's testimony.
Okay, but what he's saying is he has no discovery of even who your experts are, so how's he going to read all these articles?
I understand that. As the court knows, and we anticipate, and I think Mr. Unetti is going to address this with the court soon enough, he will be getting our expert reports. We now have, finally, their final notice of what their discovery is.
Certificate of compliance.
And we are anticipating by the beginning of trial, by Tuesday, to have something in response to that. But no, we're not going to elicit an expert to sit there and read from a study or read from a treatise, if that's what their concern is.
Anything you wanted to add to this? It looks a little broader than that to me.
It is a little bit broader than that, as far as it also refers to anecdotal experiences or things of that nature, which obviously wouldn't be contained within a study or wouldn't be contained within certain materials. So I'm sure counsel is well aware, and I'm not certainly saying that they're not, as far as what an expert can testify to and what an expert cannot testify to. But essentially what an expert can testify to is facts that they personally observe based on testing or things that they do themselves. Facts in regard to things that are in evidence or things that the counsel reasonably expects will be put into evidence. But the studies themselves, any sort of anecdotal experiences that they may have had, or any sort of scientific literature is not something that is permissible to be admitted as an exhibit. So if that is something that they seek to talk about, the Commonwealth would submit that that's improper. You know, what they did in this particular case, sort of what their baseline of experience is, what their baseline as far as their educational background in order to form some sort of opinion based on the facts as the jury finds them, is certainly fine. But making any reference to, because it happened in this study, it must be true in this case, is something that's simply not permitted.
Okay.
If I may, just briefly.
Sure.
Mr. Lally uses the phrase anecdotal experience. That's the first time I've ever heard that in this context. I don't know what he means by that. But if what he means by that is bringing into court something that the expert has done or experienced or has experience with, and then relating that back to his opinion or her conclusion, isn't that what he's suggesting Mr. Whiffen do with his in-court experiment? That sounds like an anecdotal experience. But that's just me. I think we have to take this on a case-by-case basis and figure out what the experts are going to say. I don't know what anecdotal experience means. So I can't really defend against that because I've put hundreds, if not thousands, of experts on the stand. I don't know that I've ever asked, can you tell the jury what your anecdotal experience is with fill in the blank? So I'm not sure what and I'm not being glib, I just don't know what that means. So I don't know that the court can adequately rule on it. I think this may be something that we wait until the...
So let's get the list of the experts. Take a look at the Commonwealth's the defendant's expert discovery to you, and you can raise it again.
Thank you, Your Honor.
Thank you, Your Honor.
So, Jim, let's say no action taken. All right, 27. I'll hear you, Mr. Lally.
Yes, so, Your Honor, this motion eliminates in reference to prohibiting reference to any federal investigations conducted by the U.S. Attorney's Office or the Federal Bureau of Investigations. So to this point, the U.S. Attorney's Office has publicly confirmed that at no time has the U.S. Attorney's Office named any person or entity as a target. So any sort of reference to, and essentially what they've stated throughout the course of, and I know the court has had a chance to review those materials, but what they state is essentially their investigation into some unnamed criminal activity or some unnamed crime or there's nothing specific to any specific person or entity that is contained within those materials. So what the Commonwealth is submitting is that any reference to the fact that those things occurred is therefore unfair, essentially biases against one side or the other based on that, and it really has no relevancy. As far as making reference to, if counsel at some point, either side, wants to make reference to testimony or statements, reports, things of that nature that were provided in the course of that discovery pursuant to the TUI, obviously that's perfectly permissible, but it also can be done without making reference to where that item came from. As far as you testified previously in relation to some investigation on such and such a date, you spoke to a law enforcement agent on such and such a date and you said this. So if it's needed for those kinds of reasons, as far as impeachment and whatever, that's obviously perfectly permissible, but any reference to that in front of the jury, Your Honor, is something that the Commonwealth would submit is simply impermissible and irrelevant to the facts as they pertain to this case. So for those reasons, the Commonwealth would ask that this motion be allowed.
Is there an objection to this?
There is. Your Honor, the Commonwealth's position can be basically summed up in their moving papers with the following sentence that they drafted. The proceeding would be unfairly prejudiced if the defendant is permitted to rely on the mere appearance or existence of a federal investigation, especially where the investigation was shaped and influenced by the defense. First of all, the defense does not and did not shape or influence any federal investigation. The federal government is more than capable, Your Honor, and I think the Commonwealth knows this, of making its own decisions and about its own investigations. Second, and just as importantly, the Commonwealth cites no authority whatsoever that stands for the proposition that the mere mention of a federal investigation prejudices state court proceedings in any way, shape, form, or fashion, and that's because there is no authority. That authority does not exist. But most importantly, and this is critical, it is going to be critical to give the trier of fact, this jury, the proper context in which every one of the statements or every bit of the evidence is presented and how it came to light. It's essential for the jury.
How are you going to do that? How do you propose? Is somebody from the U.S. Attorney's Office on your witness list to come in and talk about it?
There are federal agents. No. We don't anticipate presenting the fact that there's a federal investigation.
Isn't that what this does, if you mention it?
No. What this does,
explain to me why that's not so.
That's what I'm doing.
Not yet, you haven't, so please explain that.
As the court knows, it's essential that the jury is given the context in which every single statement, whatever the statement might be, is brought to light.
Does that mean, do we say, in the prior trial that resulted in a mistrial, you said this?
No, but you would say, when you were speaking with Officer Smith or Officer Jones from the Canton Police Department at the Canton Police Station in this particular context, did you say this? When you were questioned by the Commonwealth's attorney in this proceeding, did you say this? When you were questioned by the United States attorney in this hearing, did you say that? That's what we do. Otherwise, it's perpetrating a fraud on the jury. The information that's gleaned during the federal investigation was revealed, Your Honor, importantly, by a neutral third party, a neutral body that's not connected in any way to this case. The Commonwealth has a stake in this case, very obviously. The defense certainly has a stake in this case, but the federal authorities have no stake in the case of the Commonwealth versus Karen Reed. Thus, the evidence procured by that neutral agency, which is independent of the case, is subject to a different and completely different level of scrutiny, a completely different level of assessment by the jurors. That is an important fact. There is no other way to truthfully and honestly present this evidence to the jury. Think about some of the questions that the court just posed. What were the circumstances in which you changed your testimony, sir? He's going to say, well, I changed my testimony, potentially, when I was called before a federal grand jury and I was asked questions under penalty of perjury. Why did you finally admit certain things when you were confronted with additional evidence, ma'am, and where did that evidence come from? Well, I was called before a grand jury and I was asked, or I was I was interviewed by a federal agent and I was asked or confronted with additional information, text messages, phone calls, etc. Or the third example, where did that additional evidence come from, officer? Text messages, phone calls, private communications. Oh, it came from a hearing in which I was questioned by a United States attorney under penalty of perjury in front of a grand jury. The jury's entitled to those answers in that context. If we were to do what Mr. Lally suggests, if we were to take that invitation, oh, well, you were asked by a prosecutor at a former hearing XYZ. That would leave the jurors with the imprimatur of the idea that the Commonwealth elicited those questions, that the Commonwealth did their job, when we know, in fact, it didn't. The answers to those questions directly go to Ms. Reed's Bowden defense. Bowden talks about the inadequacy of an investigation, obviously, and Mr. Yannetti can talk more about that in just a second. We have information that a different agency was able to uncover information that the state investigation ignored. That's important, and it's important for the jurors to be able to weigh and balance that information and how the information came to light. If the truth is actually hidden from the jury, which is what the Commonwealth is asking the court to do, that the evidence was produced was the product of a third party, the truth being that the evidence was the product of a third party inquiry, unconnected to the state court case, then that jury is left with a false impression, false information, and it'll be unable to properly assess the true facts, which is what we're trying to get to, the true facts. Why is the Commonwealth so intent on hiding the truth from this jury? I'll submit.
Okay. I'll likely rule on that today. So, number 28, Mr. Lally.
Thank you, Your Honor. So, again, similar to the motion previous to it, the Commonwealth is not seeking to hide anything from the jury. What the Commonwealth is simply seeking to do is ensure that whatever information that's provided to the jury is actual admissible and relevant information and not the product of rank speculation. So this motion is seeking to prohibit reference to any pending internal affairs investigation or unfounded allegations of misconduct. And really, primarily what we're talking about here is any sort of internal affairs investigation related to Trooper Proctor and the 20-something-year-old civil case which resulted in no findings of liability that was referenced by counsel in their motion to dismiss with reference to Sergeant Lank of the Canton Police Department. Under the case law, including McFarland and Graham, the most recent case law, what they essentially attribute is that those types of information, when there is no finding of liability, there is no sustained finding of misconduct, there is no findings of liability by the party at question, that is simply not admissible. And so for those reasons, the Commonwealth submits that this motion should also be allowed.
All right, who's arguing this for the defense? And Ms. Little, what I need to know is what exactly you intend to introduce and how you intend to introduce it.
Thank you, Your Honor. I think it's somewhat premature for the court to rule on this issue. Obviously, the testimony of both of these witnesses is going to be highly relevant as to whether this particular information is relevant. We are still actually receiving information with regards to the internal affairs investigation as recently as yesterday. So I'm happy to kind of defer ruling to the court and then address this as it comes up. I think the court will be in a much better position to rule on this issue once the witness testifies.
All right, so what would be helpful to me, once you know what it is you think you're going to try and introduce, to tell me how that complies with the holdings in both McFarland and Graham.
There are independent reasons why that is admissible outside of McFarland and Graham.
Okay, so I need to know all of that.
Sure.
Okay.
Thank you.
So I'll take this under advisement, and how much time do you need to give me at least a general response now? Can you have it by Tuesday?
We can do that, Your Honor.
Okay. All right, so I'll hold off on that, Mr. Clerk.
Yes, Your Honor.
All right. So number 29, Mr. Lally.
So this motion, Your Honor, is essentially entitled Motion to Eliminate for Advance Notice if defendant intends to cross-examine any witness about alleged bias and request for a pretrial ruling on whether proposed evidence demonstrates a plausible showing of alleged bias. So the Commonwealth is not stating that there are no statements, as the court is well aware, that could be interpreted to reflect bias and could be used by counsel in cross-examination. What the Commonwealth is not suggesting, and bless you, is for any prohibition on any statements whatsoever. What the Commonwealth is seeking here is a ruling as to what precise statements the defendant seeks to introduce in regard to that, so that the court can make a ruling prior to the witness testifying before the jury as to exactly what's in play and what is going to be admissible and what's going to be allowed, as far as, obviously it's not a perfect world, and if a witness were to answer something in a way that would then open the door for further material to come in, that's understandable, but at least a preliminary showing as to exactly what the defendant submits are the statements they wish to introduce in relation to this issue.
Isn't the defendant given broad range and cross-examination as to bias?
Yes, and that's why I indicated early on that I understand that there is some, that there certainly is some areas that under the law, whether or not they're true or not, are able to be explored as far as cross-examination is concerned. But what this motion simply seeks to address is there are restrictions to that. It's not unfettered, it's not, just anything and everything that they could possibly think of as say as far as accusations go.
Is there any particular type of testimony you're concerned about? I mean, is there anything in particular that you say they should not be permitted to go into? Based on what we've heard throughout the pendency of this case, is there anything? I'm reluctant to tie the defendant's hands in any way on cross-examination without knowing exactly what it is you think is improper.
Okay. And what I would do, Your Honor, what I would suggest is similar to the other motions that we spoke of before. I can provide a supplemental with more specifics as to what the Commonwealth's concerns are,
Okay.
If the court would find that helpful.
Yes, I can't rule on this as is. So is there any objection to that? Mr. Yannetti, you're nodding.
Well, no, I think that makes sense.
Okay.
It was Ms. Little's motion.
Oh, I'm sorry. I saw you
I don't
nodding.
want to step on her toes.
No objection to that, Your Honor.
Okay. All right, so why don't you do that? So, Mr. Clerk, we'll hold off on ruling on this until we get something from the Commonwealth.
Okay.
So Commonwealth will clarify. Right, and then no action taken. All right, so as you know, third-party culprit and Bowden are often argued together, often presented together. Why don't we just deal with the two motions together? So Commonwealth's file, you're number 30 and 31, Mr. Lally. Mr. Yannetti, are you arguing both? Does it make sense to sort of keep them together?
I agree that they should be kept together.
Yeah. All right, so why don't I hear you as to your concerns on both, and as you know, sometimes third-party culprit, as it goes to Bowden, is different than just straight third-party culprit. And actually, it might save us a lot of time. Is that what you intend to do, Mr. Yannetti? Third-party culprit as it goes to Bowden, or straight third-party culprit as well?
Definitely third-party culprit as it goes to Bowden, that's for sure. And then depending on how the evidence develops at trial, there may be, an offer to offer third-party culprit evidence with regard to third-party culprits. But I think I can speak further to that in response.
Mr. Taillight, go ahead. You can argue these however you want to argue them.
No, I would argue them sort of in that vein, Your Honor. So understanding that based on the state of the evidence, as I anticipate it to be, and in any case, regardless, I think a defendant in any criminal case has a much better shot, essentially, at getting evidence in regarding to Bowden as sort of a backdoor through, as to third-party culprit as sort of a backdoor through a Bowden defense. So what I'm primarily concerned with, Your Honor, is motion to eliminate number 30, because as the court is well aware, there have been a number of theories of speculation, rank speculation, opinions without any evidentiary support, names of certain people that have been dropped at this microphone by counsel at different pretrial hearings who are not witnesses, who have nothing to do with this case, who don't know anything about this case, who counsel, when they said those names and sort of dropped those whatever they supported to be facts, knew that they had nothing to say and nothing to do with this case. What I'm concerned about is whatever is acceptable as far as believability when it comes to arguing things in pretrial motions, shouting things from courthouse steps, or bandying about on Twitter is not what we do here. And so now it is a time where counsel is going to be relegated to what is actual, admissible, relevant evidence. And what I'm asking for in this motion is for the defendant, through her counsel, to actually provide any admissible or relevant evidence that pertains to third-party culprit, which to this point they have not done. So if this is something that's going to be raised as an issue on its own, as the court is well aware, what the case law indicates is that the acts of the other person are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as a person who committed the crime. It has to be specific. It has to be to at least a specific realm of person or a specifically identified person who would have motive, opportunity to commit the act with which the defendant is charged. And up until this point, I have not seen anything specific as to that. As it pertains to the Bowden motion the Commonwealth filed, what the Commonwealth is asking for there is notice and voir dire in relation to a Bowden defense. So if there is, again, going to be some, I don't think the evidence comes anywhere close to a Bowden instruction, but certainly what the courts have said over time is that a Bowden defense is something that if the evidence warrants it, counsel can elicit testimony in regard to it or attempt to and make arguments in reference to it. So I'm not seeking to preclude counsel from making arguments or from counsel asking questions. What I'm seeking clarification on is what exactly, and again, this is from a position of operating without any information whatsoever as to what a defense may be. And understanding that counsel was not required to provide any information until the Commonwealth filed its certificate of compliance. But there's been, regardless of whether they were required to or not, I'm going into trial on Tuesday without any information whatsoever as to who they've spoken to, what their what statements they might be, who their witnesses are, or anything of that nature. So for those reasons, the Commonwealth feels it appropriate to at least file a motion to be given notice as to exactly what the defendant intends to do. This trial by ambush is simply not something that's permitted by the case law, and that's what the Commonwealth is seeking to prohibit in that second motion. Thank you.
Okay. All right, Mr. Yannetti, I'll hear you.
Thank you.
And though they're argued together, I do want you to also start with the third-party culprit alone, not third-party culprit as it goes to Bowden, but third-party culprit alone, because of all those factors that I told you, as you well know, the case law is clear, that I have to consider. And if I had to do it now, and you know I can do it pre-trial, right? You know that today I can just exclude it. I'm not inclined to do that, but I need to be able to make those decisions, to to weigh those factors, because right now I have zero information on
Right,
this.
I understand that, Your Honor, and that was my plan going into today anyway. So the initial question is, why is there a third-party culprit defense? Why is it relevant? And we start, Your Honor, with the fact that our forensic medical examiner, Frank Sheridan, a pathologist, forensic pathologist who has performed himself thousands and thousands of autopsies, has already submitted a sworn affidavit to this court that John O'Keefe's injuries are consistent with having been in a fight and are not consistent with having been hit by a car. Since he submitted that affidavit, the federal authorities have provided us with their reports, whereby FBI experts also corroborate that John O'Keefe's injuries are not consistent with having been hit by a car. They employed experts in biomechanics and kinematics who have reviewed the evidence in this case, and they've confirmed that the physical evidence essentially shows and doesn't show what Dr. Sheridan has opined. So therefore, if John O'Keefe was not hit by a car, that means that Karen Reed did not kill him. And we know that John O'Keefe did not die of natural causes. This was not a heart attack or a stroke. John O'Keefe was injured. He was mortally injured. If he was not hit by a car, as both our expert and FBI confirmed, then he was attacked. And if he was not hit by a car, then there is a third-party culprit or culprits. So by asking this court to prohibit the defense from introducing evidence that others had the motive, opportunity, and the means to attack John O'Keefe, the Commonwealth is essentially asking this court to prohibit Karen Reed from being able to defend herself.
So I don't think they're asking that you be prohibited from doing that. They're asking first to have you tell them what that is.
Right. Well, this is, Your Honor, I'm getting to that in terms of
All right, so go ahead. You have your remarks.
that we're either required to give them or not. It is not our job to solve this case for the prosecution. It's our contention. They had the opportunity to do that, but they failed. It is not our job to name a specific third-party culprit. We do not have to prove that Brian Albert or Colin Albert or Brian Higgins or some combination of them intended to kill John O'Keefe. We don't have to prove that any of them attacked John O'Keefe such that he eventually died. They have to prove beyond a reasonable doubt that they didn't. But the fact of the matter is there is evidence that all three of them had a motive, had the opportunity and the means to attack John O'Keefe. Now, the Commonwealth cites Commonwealth versus Conkey in their motion, and as this court started the discussion on this issue when you first took the bench, Conkey makes clear that a defendant has a constitutional right to argue that somebody else may have committed the crime. And certainly, no, the acts of that person can't be too attenuated in time or method of operation, as Mr. Lally mentions. But in terms of being the right time period, Your Honor, you can't get any closer than their presence at the scene at the very time that John O'Keefe was killed. And in terms of the method of operation, given that we have evidence that he was not hit by a car and that he was attacked, all three of these men, either alone or in combination, possessed the ability to attack him with or without a weapon. I mean, that's a very low standard here. The Commonwealth acknowledges that. It's a low standard of simple relevance. And the evidence here establishes relevance. Now, I would note, Your Honor, the Commonwealth cites Commonwealth versus Finney. I don't know if they realize this, but that was my case. I represented Roland Douglas Finney before the Supreme Judicial Court, and I represented him at his motion for new trial and at his retrial. And that case, the Finney case, provides strong support for the introduction of third-party culprit evidence here, irrespective of a Bowdoin defense. In fact, the reason that Mr. Finney's conviction was overturned was that his trial counsel failed to pursue a third-party culprit defense. And, Your Honor, the third-party culprit defense in Finney was weaker, far weaker than the third-party culprit defense we have here. The evidence of motive in that case was that the third-party culprit made derogatory statements about the victim after she was murdered. No witness in that case put the two of them together. No witness in that case put the third-party culprit at the scene of the murder where the victim was murdered. There was some consciousness of guilt evidence, similar to what we have in this case. But in Finney, the SJC ruled that not only was that enough for a defense attorney to present a third-party culprit defense, but he was ineffective for not doing so. And as the court has also touched upon, the SJC found that on the basis of that third-party culprit evidence, which is weaker than what we have here, there were substantial connecting links between that third-party culprit that justified the admission of hearsay in that case. And I want to make it clear, we're not looking to introduce any hearsay statements, so we don't need substantial connecting links here. Now, Your Honor, I could go through with the court the specific evidence we have with regard to motive, opportunity, and means with regard to the three Commonwealth witnesses that I've named.
So go ahead.
Happy to do it. Starting with Brian Higgins. He was present at 34 Fairview Road on January 28th to 29th. He was close friends with the homeowner, Brian Albert. He had a prior romantic interest in Karen Reed. He did not expect Karen and John O'Keefe to be at the Waterfall, that bar, on January 28th. Karen Reed did not greet Higgins, despite the fact that they had previously exchanged flirtatious texts and that she had been at his apartment one evening, although there was nothing that took place between them any more than a peck of a kiss. At the Waterfall, Higgins does not engage with John O'Keefe. He does not say goodbye to John O'Keefe and Karen when he leaves, but before he leaves, he texts Karen, and that text was something to the effect of, well, with a lot of M's. We know that there was a preservation order from this court, your predecessor, Judge Krupp, to preserve his cell phone, and that Trooper Proctor gave him an edict, an order to serve on Brian Higgins, and he left it at the front desk of the Canton Police Station for him, and that Higgins, we learned through the federal investigation, Higgins became angry, demanded that Proctor come back, and he essentially upbraided him and read him the Riot Act, which shows a little bit about Higgins' personality. At the end of the night, everyone discussed going back to 34 Fairview, and when he gets back to 34 Fairview, he texts not Karen, he texts John O'Keefe at 12:20 a.m. He testified before the federal grand jury that he had no knowledge that they had been invited to 34 Fairview, but that is contradicted by this text message. And the inference is that he was coaxing John to come to that house. And, you know, we're not saying this gives him a motive to kill John, but we don't have to show that. Any motive to feel hostility or animosity towards John O'Keefe goes to his motive. And, Your Honor, when Brian Higgins and Brian Albert are in that house, they're the only two people who are unaccounted for when the rest of the group was in the kitchen. And they claimed that they were looking at photographs together. And we have evidence that they were in the basement. We believe that Brian Albert made a mistake before the state grand jury by testifying they went upstairs to look at photos. Brian Higgins says unequivocally that the only place the two went was into the living room to look at photos and military ribbons, whatever they were looking at. Brian Higgins did not know that Brian Albert had said they went upstairs. And he also testified he had never been upstairs at Brian Albert's house in his life. That means that if Brian Albert said they went upstairs, they're coming up from the basement. And before leaving 34 Fairview, Brian Higgins testified he was parked right in front of the mailbox. He would have had to have walked by where John O'Keefe's body was. His headlights, when he got in his vehicle, would have been illuminating where John O'Keefe's body would have been in the yard if it were actually there. So how does he not see it? He then goes back to the Canton Police Station at 1:30 in the morning after leaving 34 Fairview. He claimed to do some administrative work. But then he admitted to the federal grand jury that he was there to move his car because of the upcoming snowstorm. This suggests that he was fabricating a reason for going back to Canton Police to establish an alibi for himself. He was asked several times at the federal grand jury if he had any conversations with anyone before he went to bed, and when was he notified that John O'Keefe was dead. In the morning, he said. He testified under the pains and penalties of perjury that he had absolutely no contact with any person that night for any reason whatsoever. But he apparently was surprised that the federal authorities had subpoenaed his phone records, and he had to admit, and he did admit under oath, he made that 2:22 a.m. phone call around the same about 5 minutes before Jennifer McCabe is Googling how long to die in the cold, about 8 minutes before Brian Loughran, the plow driver, first drives by the house and sees no body at all. And the next morning, Brian Higgins, the first person he spoke to was Brian Albert.
I'm going to stop you for a minute. I think we need a break, Madam Court Reporter. Do you need a break? Can you go? How much longer do you think you have with this, Mr. Yannetti? How many more pages, or how long you think?
Yeah, I've got about, in terms of my recitation of the facts, I've done about a page and a half, and I've got 3 left.
Madam Court Reporter, would you like to take a little break? It's hot in here, and you've been going nonstop. Okay, let's take a 10-minute break.
All rise. We'll stand for a brief recess.
All right, Mr. Yannetti, go right ahead.
Thank you. Your Honor, I left off with the morning of January 29th. The first person that Brian Higgins spoke to was Brian Albert. He had missed a call from Chief Kenneth Berkowitz earlier. Immediately after getting off the phone with Brian Albert, Brian Higgins drives back to 34 Fairview, where he has a meeting with just about all the witnesses in this case: Brian Albert, Julie Albert, Jennifer McCabe, Matthew McCabe. And immediately after that friends and family meeting, on his day off, which is a Saturday, he returns to the Canton Police Department, where he speaks with all of the first responding officers who had anything to do with this case. So this is a quote-unquote witness accessing and communicating with all the first responding officers, we would argue monitoring what they're doing in regard to the investigation. According to Brian Higgins, he admitted that Chief Berkowitz is one of his best friends, and that's why he had access to all these people. We have a law enforcement witness who will testify with Karen Reed long time.
So is this a name that's been in the materials? Is this a name known to the Commonwealth, or
Yes.
is this somebody new? Okay.
We've now received video surveillance from the Canton Police Department that shows that there is an interior camera in the Sallyport garage where the car was housed. But during the exact time that third-party officer indicates that Berkowitz and Higgins were in the Sallyport together, the video mysteriously cuts out for 42 minutes. Between 5:08 and 5:50 p.m. And just to be clear here, we never get to see the condition of the taillight when it's brought into the garage. When we do see the car, we see it after Brian Higgins, Chief Berkowitz, Michael Proctor, and Yuri Buchnick have all had access to it. At 5:36 p.m., the car pings that it's arrived in the Sallyport. That's during the missing video. Trooper Proctor, Trooper Buchnick never sees Brian Higgins' phone. They speak with him. And he takes it upon himself to use his own resources, Brian Higgins, within the federal government to ask a friend, Special Agent Matt Kelch, to download only the text messages in his phone between Karen and him and John. And that's it. We have to take his word for it that we got all of them. And we certainly don't have any communications between him and Brian Albert, for instance. On February 10th, when he shows up to his interview with Troopers Buchnick and Proctor, he brings with him copies of the text that he has deemed relevant in their murder investigation. And he hands them the copies of the extraction that he had his friend do. He then calls Matt Kelch the weekend of this extracted the tests, despite the fact that it was done by a friend of his in the federal government. During the federal proffer, Brian Higgins admits that he had been served with a preservation order, and the Commonwealth told him he could destroy his phone despite the order. He then drives to a military base on Cape Cod, opens his phone, breaks the SIM card, and throws the phone away. And he says that he discussed destroying his phone with Brian Albert. Brian Albert also destroyed his phone. And Brian Albert said that he had received some text that concerns him as an explanation. And after that, Brian Higgins changes his phone number and changes his cell carrier. In short, he was present that night, he had a motive, and there is plenty of consciousness of guilt cover-up evidence with regard to Mr. Higgins. Moving on to Colin Albert. Shortly before January 29th of 2022, Colin Albert lived with his parents, Christopher Albert and Julie Albert, on John O'Keefe's street, just 2 doors down. We have evidence of bad blood between Colin Albert and John O'Keefe. We have evidence.
How old was Colin Albert at that time?
I believe he was 16 at that time.
Okay.
We have evidence that Colin Albert and John O'Keefe used to get in confrontations because Colin Albert used to cut through his yard without permission, and John O'Keefe was not happy about that. We have evidence that Colin Albert used to throw beer cans intentionally into John O'Keefe's bushes, and John O'Keefe was not happy about that. We have evidence that Christopher and Julie Albert knew of this conflict. We have evidence that they referred to John O'Keefe as Nebercracker. That's a character from I think a kid's movie, who was known as the get off my lawn guy. When John O'Keefe and Karen Reed were vacationing in Aruba over New Year's Eve 2022, the Alberts, Christopher and Julie, taunted him. They went to his porch and they had photos taken of themselves drinking on John's property when he wasn't there to do anything about it, evidencing they knew how upset he was at what Colin Albert had been doing. Now, the investigators in this case, Your Honor, including Michael Proctor, kept Colin Albert's name completely out of the police report. When this case began, I had no idea who Colin Albert was. I received a tip right from the jump that Brian Albert and his nephew had beaten up John O'Keefe. I didn't even know Brian Albert had a nephew at that time. But after receiving the tip, I learned of the conflict that Colin Albert had with John O'Keefe, so I sent a letter to Mr. Lally, I believe by certified mail. I knew that the DA's office was planning to present evidence or witnesses to a grand jury, and at that early juncture, before anybody had asked them to indict, I notified the DA of 3 potential suspects, the ones that I'm talking about now: Brian Higgins, Brian Albert, and Colin Albert. After he received that letter at our next court appearance, I'm sure Mr. Lally can confirm this, he acknowledged that both Brian Albert and Brian Higgins would be testifying or had testified before the grand jury, but he questioned why I included Colin Albert in my letter. He told me at the time that he had no evidence that Colin Albert was there that night. However, after receiving my letter, lo and behold, multiple witnesses testified that Colin Albert was at 34 Fairview the night of January 28th to 29th. And now the DA will argue, I'm sure, at trial, that he left before John O'Keefe arrived. We don't find their evidence compelling. We don't accept it We are not required to accept their theory of the case. We're entitled to present a defense. His presence at 34 Fairview gave him the opportunity, along with the motive, to harm John O'Keefe. With regard to Brian Albert, Your Honor, this is a well-connected, well-known, powerful family in the town of Canton, Massachusetts. Brian Albert was present at that home when Colin Albert was there. Colin Albert is a member of the Albert family. He's nephew of Brian Albert. We have evidence that Brian Albert had expressed hostility toward John O'Keefe as well. And we know that he initiated a phone call with Brian Higgins at 2:22 in the morning. He reached out to Brian Higgins. And then he picked up the phone when Brian Higgins came back, and they spoke for 22 seconds. And they never revealed any of that to investigators. Again, consciousness of guilt, and perhaps most of all, Brian Albert is a first responder. He is duty-bound to help somebody who's in trouble. He was notified that John O'Keefe was in trouble. Brian Albert stayed in his home. He knew what was going on outside. His sister-in-law was out there, civilians, medical personnel eventually arrived. He did nothing. That is also consciousness of guilt. Now, Your Honor, with regard to all of that third-party culprit evidence, to admit it substantively, which I would assert to the court is both overwhelming and powerful. With regard to the Bowden argument here, the police investigated none of that. That didn't come from the Commonwealth. They had a complete lack of curiosity as to what was going on in that house that night. They didn't care. Investigators never went in. The feds investigated, and that's where we got a majority of this evidence. So, you know, to the extent that the Commonwealth now claims that they didn't have notice of this, I beg to defer. They got notice of this when we got notice of this. You know, the Finney case, Your Honor, again, I'm well familiar with it. It stood for the proposition that, you know, if you want to point the finger at a third-party culprit, you've got a constitutional right to do that. And if you want to point out inadequacies in a police investigation, you have a constitutional right to do that. It is for those reasons that I ask you to deny the Commonwealth's motions.
Okay, thank you. Any response, Mr. Lally?
Briefly, Your Honor. Just first, again, what the case law requires is evidence and not just mere speculation, or saying that you have evidence is not actually evidence. I do find it somewhat interesting that Mr. Yannetti wrote apparently 4.5 pages of notes, but didn't have time to write a motion to admit the evidence that he claims that he has. He references in regard to third-party culprit, Dr. Sheridan, who indicated that the injuries are consistent with the fight. He's the same doctor who indicated that the injuries on Mr. O'Keefe's arm were consistent with the dog bite, which was then refuted by the DNA findings from UC Davis, as well as the fact that the injuries are only on one side of the arm. And last time I checked, dogs have teeth on the top and the bottom, and there's no injuries to the bottom of Mr. O'Keefe's arm. Furthermore, the counsel references the federal grand jury materials in which I would say, as has been done numerous times previously, is severely mischaracterized as to what they actually contain. So what, and it's not a crash reconstructionist as it's been alleged here before, it's a biomechanical engineer. And essentially what they did was take painstaking lengths to go to determine that the defendant's vehicle did not strike Mr. O'Keefe in the back of the head, which is simply something that no one has ever said, intimated at any point ever. There is also a medical examiner in the federal materials who concurs completely with Dr. Scortibello's findings as it pertains to the cause and manner of death. So with regard to each of these. The other thing that I would point out is counsel was counsel record with the Finney case. The Finney case relates to third-party culprit under the Bowden defense, so it's not applicable to what counsel was arguing. It is a low standard, but it's also one that the defendant here has not met. It's not one without limits. As it pertains to much of the material that it was summarized as far as speculation as to what different things counsel feels mean from various things regarding Mr. Higgins, Colin Albert, and Brian Albert. Just starting with Colin Albert, because that's frankly the easiest. He wasn't at the house, and that's what the federal materials confirm with each of every single of the witnesses that were spoken to by the district attorney's office or the troopers or testified to the state grand jury. They testified to the exact same things in the federal grand jury, that Colin Albert had left the house prior to the defendant and the victim arriving there, and there's absolutely nothing to combat that whatsoever, other than, again, just rank speculation. So opportunity would be a little bit amiss if he's not even there at the same time as Mr. O'Keefe, regardless of the invalidity of any sort of ill feelings or ongoing feud that's purported from whatever unknown evidence counsel claims to have. In regard to Mr. Higgins, that was a fanciful story, but again, there's actually no actual evidence of most of those things, or at least the imputations or the connotations the counsel wants to put behind that. Whatever he feels things were observed. So again, I'm not sure where the evidence from this is coming from. What I'm also a little confused in regard to is that if counsel is merely relying on materials within the federal grand jury and just learned of them at that same time as we learned of them when materials were provided pursuant to TUI, then it's a little peculiar that the exact same arguments were being made throughout the pendency of the case well before counsel was provided with any of those federal materials. What counsel just went through is essentially a list of rank speculation and not actual evidence. As far as the mysterious portion that's missing from the Sally Port, there's a number of different, it's a motion activated camera for the most part. The other thing that I would direct the court's attention to, as it was contained within the state grand jury proceedings, is there is cruiser camera video from the Canton Police cruisers. Specifically, there is cruiser camera video from Cruiser 682. Specifically, there is cruiser camera video from Cruiser 682 at 8:22 in the morning when a lieutenant and sergeant from the Canton Police on their own go over to One Meadows Ave, which is the residence of Mr. O'Keefe, to do a well-being check because they had not received any information as to how the children were or if they were there being attended. Parked it when they stopped there to see if Mr. O'Keefe was there before then piling into Ms. Roberts' vehicle and proceeding to 34 Fairview. And what you can see within that cruiser camera video at 8:22 in the morning is the damage to the right rear taillight of the defendant's vehicle. Well before the defendant had then come back to the house after the hospital and then gotten in 3 separate cars with her family and driven in a blizzard all the way back to her parents' house in Dighton, and then the vehicle had then been towed from Dighton back to the Canton Police Station by the state police with the assistance of the Dighton police.
Do you know what exhibit number that is before the grand jury?
I believe it's 56, but I can certainly locate that information. And again, as far as Brian Albert is concerned, I heard nothing other than he's apparently in a well-connected family in Canton, and Colin is his nephew who wasn't present at the house when Mr. O'Keefe and Ms. Reed were present at the house. So again, I think it's a stronger argument, certainly, if we're trying to bootstrap onto a Bowden defense, and counsel will probably likely be allowed to at least investigate that as far as impeachment, cross-examination, things of that nature, but there is absolutely nothing beyond just a fertile imagination and rank speculation as it applies to a third-party culprit defense. And for that reason, the Commonwealth's motion to exclude it should be allowed.
All right.
The only thing I'd like to correct, Your Honor, is, well, or at least point out, is that, the car pinged at 5:30.
So hold on until you get to the
Yeah,
microphone.
I'm sorry. The car pinged at 5:36 p.m., indicating that it was in the Sallyport. There is an outdoor camera where you can see the car about to enter the Sallyport at 5:31. Of course, you can't see the taillight in that outdoor, camera. But Mr. Lally just argued before you, well, the reason why there's no, video of the car between 5:08 and 5:50 is that it's motion activated. And I just ask the court to use common sense here that if the car's entering, and by the way, the car's there at 5:50 with a couple of people around it. When the camera comes back on, you see the car. So unless it was teleported in a split second so that the interior camera would not pick up motion, it drove into the Sallyport. I believe that's the definition of motion, and it should have been picked up according to Mr. Lally's own words.
Okay, so when you walk away from the microphone, it's harder for the court reporter to hear you, Mr. Yannetti.
And I apologize, Judge. It's according to Mr. Lally's own words, it should have picked up the movement.
Okay. All right, so I believe that's the last motion. So why don't we recess until 2 o'clock? And I'll see you back here at 2. Mr. Lally, will you have Ms. Gilman, who I did see walk in here at one point, set up the screen right where we normally keep it?
Yes, sir.
Thank you.
You are muted. You are unmuted.
right, Jim, I need just a minute with the computer, please. Okay, thank you.
Back on the record on the Karen Reed matter.
Okay, so good afternoon, council. Good afternoon, Ms. Gilman. I appreciate you being here. Before we see this video, just briefly, I just want to say that there were really only 2 motions that I'm comfortable with deciding by the 2 o'clock call here. I don't know if I already allowed that, but that's allowed. And the Commonwealth's motion eliminate, Jim, I think this is 317. Commonwealth's motion eliminate to prohibit reference to any federal investigations conducted by the U.S. Attorney's Office or FBI. So that will come into evidence the way that it typically does here in Massachusetts. You can question as to a date where the statement was made under oath, and we can discuss it as it gets closer in more detail. So the other motions are under advisement. We'll talk about that when we come back to sort of housekeeping matters at the end of the day. So do you have that video all pulled up, Mr. Lally, for me to see?
Yes, Your Honor.
Okay.
And Your Honor, for the record, it's a little bit lengthy as far as the entirety of the video. The portion that I would be submitting to the court is from 7 minutes and 4 seconds until 9 minutes and 55 seconds.
Okay. Can we, thank you.
So we locked up the house. The back door we just did the knock
Okay. Can you explain to me what the process is right now?
Absolutely. So you're going to be booked just like last time. Go through the same process. It's going to be a little less time consuming because we're not going to do major case prints because we did those last time. Once you're booked and you go through this portion of it, we'll let you make a phone call just like last time. We'll make a phone call. Your parents will be able to bring you whatever other additional need, things that you need.
Yeah.
And then tomorrow morning, you'll go and be arraigned at Norfolk Superior Court on the charges that were, I'm sure you'll go over the charges again with you on the warrant.
But I'm on bail, so how can I be spending the night here again?
All right, so I'll explain that portion to you, as long as it's not going to interfere with you. Are you ready to go?
Yeah, I'm just waiting for Ram to.
Okay. So initially, your arrest was on probable cause out of the district court. Okay. So the charges that you were arrested on initially were out of district court, out of Stoughton District. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving the scene of a death. Okay? So those are the charges that grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in Devon. Okay?
So bail doesn't apply anymore?
Typically, I'm not, so we don't set the bail. But typically, once murder comes into play, people don't get bailed out.
So it's not manslaughter anymore, is that the difference?
That's correct. It's a higher degree of taking a life. Okay, so that's the charges that you're being charged with now. And you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian McCall Albert. I mean, we're all in on the same joke, right? My taillight was cracked and John was pulverized.
Okay, you need to abide by the rights that were afforded to you, okay? So you can talk if you want. If you want to tell us what happened, that's fine, we'll listen, but you were ready to use your rights, okay? And I'm sure he's gonna do it again. All right, if you want to talk to us, you want to give us a story, definitely. We'll take it.
No, I mean, I know you already know the story, so I don't need to.
All right. How long is the entire tape?
So that is Trooper Pai, who was the arresting officer from the barracks. So it goes, I believe, at least 90 minutes or so.
All right, do you have the entire, we're not playing it now, but do you have the entire video? All right, I would like it marked for identification.
Sure.
I'd also like a copy of it so I can view the whole entire thing, put it all in context. I never like to see just sections.
Sure.
Can I get that for the weekend as well?
Oh, absolutely, Your Honor. And for the record, as far as I think a lot of that sort of preliminary stuff was more meant as context for the court. You know, there's certain discussions about court procedure and things that I don't think should be put in front of the jury.
All right, so that was my concern as well. Okay, so it's something I'll watch a few times, and the whole thing as well. Okay. All right, thank you.
Thank you, Your Honor.
Aid for identification. Thank you very much.
Thank you.
All right. Okay, so housekeeping matters. A few things that I still need, as you know, before we have the jury here on Tuesday. I need a statement of the case. I know you have a short statement of the case in your proposed supplemental questionnaire. I think it needs to be more than that. So before you leave today, I'd like you all to agree on a joint statement of the case. I need witness lists. If the witnesses are going to be called, I have to read their names, as you know, to the jury on Tuesday morning. Once we get a jury, and I know none of us knows how long that might take, how long will it take to put in the Commonwealth's case? You can tell me with DNA and without DNA.
So with that piece of DNA, I don't think that's going to add much more than you know, an hour or two at the most. But best guess, given the schedule as outlined previously by the court, I'd say probably at least 4 weeks. My hope is there are some witnesses fine just in regard to administrative things as far as, you know, work in an establishment. This is a true and accurate copy of surveillance video from said establishment.
Have you had preliminary discussions about whether there would be stipulations to authenticity like that?
No, but I plan to before Tuesday.
Okay. And you'll do that, Ms. Giannetti? You'll have these conversations before Tuesday?
I'm completely open to that.
Okay. So with the Commonwealth's case going 4 weeks, how long does the defense think their case will go?
With the schedule that the court has outlined, we're estimating about 2 weeks, Judge.
Okay. All right. I need to tell the jurors how long it will take. So if you say 6 weeks, I'm going to tell them 7, which will make it longer for us to get a jury. But
Right, understood. And then there's also the X factor of how long it takes to get a jury. Right?
Oh, exactly. No, I'm going to tell them once we get a jury, it will be 7 weeks, give or take.
And just while we're on this subject, Your Honor, does the court have any idea in terms of the availability of jurors every day of the week while
We don't have jurors on Fridays.
No jurors on Fridays?
No, and it gets progressively lower as the week goes on. But we've got jurors, once we start, the trial that is impaneling has priority over all other trials. So once we start, and I expect that we'll start on Tuesday, we'll do that. So there's a couple of things about the voir dire of the jurors. So we will do the voir dire, the individual voir dire of jurors over here at sidebar. And only one lawyer from each side is permitted to ask the questions of the jurors. I think I'll probably be able to give you 5 minutes or so for each witness, no more. And I'd like to talk to you all at sidebar now about your joint proposal of the questionnaire. This is something that is not public. It won't be made public until after it's decided upon and after it is presented to the jurors and they've filled it out. So a blank copy will be available then pursuant to what the law is. So why don't I see counsel at sidebar?
Is this Sarah, Your Honor?
Excuse me?
Is this
Yes, thank you. All right, so is that everything regarding housekeeping, logistics, things like that?
Yes, Your Honor.
Okay. All right, so we'll see you on Tuesday morning. All right, just so we're clear, there's nothing else logistically or jury impanelment, right? We're good?
I believe so, Your Honor, yes.
Okay, thank you very much. All right. Thank you, so we'll see everybody Tuesday morning. So I need to see, is there Zoom off?
Goodbye.
Galoshes. You guys have never had? That's galoshes? Oh.